Section 3. Patent Infringement. What is patent infringement? The doing of any acts restricted by the exclusive rights granted to the patent owner without permission will be infringing. So, infringing acts are exactly the acts covered by the exclusive rights owned by a patent owner. However, there is one more thing. Without permission, the doing of any acts restricted by the patent owner's rights is called direct infringement, which will give rise to liabilities under patent law. We call it direct liabilities or liabilities for direct infringement. In contrast, there is a second group of liabilities that might be imposed on a party who was not the doer of those restricted acts. Instead, these parties are merely contributing or facilitating the occurrence of direct infringements. Under patent law, contributing to a direct infringement or encouraging a party to conduct infringement could also be held liable. These are secondary liabilities for patent infringements. In order to establish patent infringements, a plaintiff must prove the following three facts. Number one, the plaintiff has a right to bring action under the patent. There is a case infringing patents, but not anyone would have the right to bring the infringer in front of the court. Secondly, the plaintiff must prove that with strong evidence or acceptable evidence by the courts that the defendant has committed at least one act restricted under Chinese patent law that's considered to be infringement. Number three, the product at issue, potentially the product that's infringing, this could be an invention product or a product made or obtained through the use of the patented process. Is covered by at least one of the claims of the patent. Put it another way, the infringing product at issue may fall within the scope of protection of the patented products. The right to bring action against infringements under Article 60 of the Patent Law of China, it is a general rule or a default rule that the patentee, that's a patent owner, and any related injured party or the party who suffered from an infringement may institute legal proceedings in the courts and also have the right to request the administrative authority for patents to handle the matter. So here we mentioned about judicial remedies available to patents and also administrative remedies available to a patent owner in China. In the case of infringements, the patent owner could choose to sue the defendants in front of the courts. Meanwhile, could also go up to the patent administration, making a complaint to the administration against the infringing parties. Under current Chinese law, it is clear that a patent owner, the patentee, for sure has a right to bring action suing those who are committing or conducting infringing acts defined under patent law. However, the scope of a related injured party is not well defined under the current law. Therefore, in practice, the court has developed a set of specific rules. Basically, the injured party may refer to the licensee of a patent. So under the license contract or a contract which give permission to a third party to execute the patent might fall within the definition of injured party who may suffer from the occurrence of infringement. Number 2, the burden of proof and the importance of evidence. It is a general rule that any party, the plaintiff or the defendant, who assert a fact has a burden of proving it. Basically, it means if you claim that someone has done something, you would have the burden to prove that actually happened. If you cannot prove it with acceptable evidence or sufficient evidence, the party who claimed the facts with the burden of proving it will bear the adverse consequences. This means you claim what was happening, but you cannot prove it. Then it would be presumed that that was not happening. But in the case of patented method, as we mentioned earlier, it is so difficult for a patent owner to prove that the product at issue made by the defendants were obtained directly through the use of the patented method. Therefore, the general principle of allocating or assigning burden of proof has been evolved a little bit to accommodate the specific issue in patent infringements concerning a patented method. So the rule is that this is different from a normal claim by the plaintiff or by any party who may bear the burden to prove what he claims. Here, in the case of process patents, any identity or individual manufacturing the products shall bear the burden of proof to convince the court that the process used in the manufacture of the product offered by him or her is different from the patented process. It means it is the defendant's to prove the method used by him or her is not the method patented by the plaintiff. You see, the burden of proof to establish the mere facts of infringements being shifted from the plaintiff to the defendant. Of course, there are some specific details of this rule. Number 3, the accused products at issue must contain all the technical feature of the claim of a patent. Basically, it means the technical feature contained in the product at issue must exactly identical to the technical features of the claims defined by the patents. The claims of the patents is clearly indicated or should be clearly indicated in the application documents submitted to the patent office. Well, the accused technical solution of the infringing products contains the technical features that are identical or equivalent to all the technical features of the claim. It shall be determined that the accused technical solution fall within the protection scope of the patent. So here we have two rules to establish whether the accused products contains all the technical features of the claim of a patent. Number 1, the technical features are identical to each other, exactly the same, all technical features. Number 2, well, the defendants may change the technical features a little bit. It looks a little bit different from the technical features defined by the patent owned by the plaintiff, but that change is insignificant. Therefore, the technical features contained in the defendant's products, the accused products, are basically equivalent to the features covered by the claim of the plaintiff, the patent owner. If this can be established, the court would also come to the conclusion that the accused products constitutes infringement or the product at issue will be infringing product. So that's a general rule applicable to invention products or invention patents, utility models, and design patents. But in the case of infringements upon design patents, the establishment of infringements is a little bit more in the case of infringements upon a design patent, it is not enough to establish that the design features of the accused products are identical to or similar with the design features patented by the plaintiff. So identical or similar designs that's established by the courts, but that's not enough. That's just step one. Step two, it also must be established that the accused products is identical or similar with the products for which the patented design initially was applied for. So here, in this case, there's a design of a chair, like the rabbit. The rabbit chair, or the chair looks like a rabbit, very cute and very popular. It's a design by an Italian designer. The defendant has made a product which you may see from the pictures here on the slides. The accused product here actually are not chairs. They're LED light. So it's not supposed to be functioning as a chair so people can sit on it or ride on it. No, it's just simply for decoration purpose to put on the street. The defendants were sued for infringing the patent rights owned by the designer. The Guangzhou IP courts conclude that infringing because, well, to determine whether the products are identical or similar, the class which the plaintiff or the patent owner ever picked to ever decided or ever nominated for the design to be applied for is very important factors to be considered. But in an infringement case, that's not enough. It can go much beyond that. The courts consider many factors, including the class of goods for which the patented design was originally or initially applied for. Secondly, the specific circumstances and what the products could be used for from the perspective of an average consumer. So to the court here, the defendant's products, although not primarily for the purpose of serving as a chair, but actually people can sit on it. It could be possible that an average consumer would believe that that's a chair, or this could be functioning as a chair. So anyway, the courts conclude that in this case, the defendant products is identical or similar to the products for which the plaintiff design patents was applied for. So now you see the general rule to establish a patent infringement is that the accused product at issue contains technical features that are either identical or equivalent to the technical features patented by the plaintiff. It shall be established that the accused product is an infringing product, no matter whether the technical features are identical or equivalent to each other. The maker of the infringing product shall be held liable. However, the one being sued is not always the one who produced the product. It could also be the sellers who sell or offer to sell the infringing item, the end user who purchases the infringing item and use it for commercial purposes. For example, you buy infringing raw materials or components of machines to be used for the making of the entire machine. That could be infringing. And the one who imports the infringing item to a country where the product has been patented. In the case where the accused product contains all technical features in the claim of a patent so that the alleged infringer actually has carried all of the elements of the patented invention, a literal infringement will be established. It means the accused technical solution comprise technical features that are identical to all the technical features stated in the entire technical solution of the claim proposed by the patent owner in the application documents. However, in reality, the potential infringer may just have the patented technical features changed or modified slightly, and the change contained in the accused product is apparently insignificant or insubstantial to any person with ordinary skill in the field. The court would conclude the modified technical features are essentially equivalent to the technical features covered by the claim of the patent so that the accused product at issue is infringing anyway. This is called the Doctrine of Equivalents. It exists to prevent defendants from taking the essence of the patented invention while skirting the literal language of the claims. Equivalent features refer to those which achieve substantially the same function and generates substantially the same effects by means substantially the same as the technical features stated in the claim and can be envisaged by a person with ordinary skills in the art without making inventive efforts. Basically, it's reiterated what we explained earlier. The opinion of the Supreme Court of China here basically says to determine whether the features contained in the accused products is equivalent to the technical features contained in the claims of the patents or not. As to judging the key differences between the two products, if the differences in terms of the technical features are not significant, they're basically insubstantial, and the differences it is so obvious to a person with ordinary knowledge and skills in that field of technology, then the change would not be considered as novel or significant change. In that case, these features contained in the accused products will be decided as being equivalent to those covered in the claims of the patent. No matter the accused product is infringing because of identical technical features or equivalent features, unauthorized acts of making the product or using, offering to sell, selling, or importing the products may all constitute infringement upon the patents. These are known as direct infringements, and those who committed these infringing acts could be imposed primary liabilities for infringements without taking account the mental elements of the infringers. So the infringer cannot argue that, sorry, I did not realize that this product was infringing, so I bought it and used it in my factory or use it as the key components of my products. I was not aware of that. So being innocent is not an effective defense against patent infringements. No matter you realize that the products listed in your shop or the components used in your products were infringing or not, your single acts of selling the products, of using the products for commercial purposes, would anyway amount to patent infringements. But if you can convince the court that you were innocent, it might be possible for the court to limit the amount of damages. But the mere fact of being innocent has nothing to do with the establishment of patent infringements in any case. In terms of the limitations on monetary relief available to a patent owner in the case of innocent infringements, We will be back to this topic in the following slides. Whereas in the case of indirect infringements, where a third party who were not the doer of those acts, making, using, selling, or importing, offering to sell, as defined under patent law, but merely facilitating the occurrence of direct infringements, for instance, by means of providing raw materials or key devices or a venue for the defendants, for the infringer to make infringing products, or renting a place for the infringer to sell the infringing products. These third parties contributing to the occurrence of the infringements would also be held liable indirectly. To impose indirect liabilities, secondary liabilities, for facilitating or contributing to infringements, it is critical to examine the mental elements of the third party. So the rules of indirect infringements bring into play the mental state, which means whether the third party has knowledge and intent of facilitating and contributing to the occurrence of infringement. The patent law traces its infringement principles to tort law in the US, for example. It's been, for a long history, inducements and contributory infringements evolved to address infringing activities that lacked the elements of direct making, using, or selling of the patented invention. Today, the theories of inducements infringements and contributory infringements have been widely applied in case law and also in legislations in a country like China. In the US law, the historical developments of secondary liability rules demonstrates that there are majorly two sets of secondary liability rules. Number one, liability is for inducements to infringements. The secondary liability rules has been codified into the US legislation, the Title 35 of US Code, which is the Patent Act of the United States. In Section 271B, it is provided that whoever actively induces infringements of a patent shall be held liable as an infringer. So the key requirements here, active inducements, means the defendants must be aware of the fact that the direct infringement being induced to commit infringing conduct. And there must be active positive steps taken by the defendant to induce the direct infringers to do wrong things. Number 2, liability is for contributory infringements. Section 271C provides that a third party shall be indirectly liable for selling a component of a patented invention if A. The components constituting a material part of a patented invention. B. Knowing component is specially adapted to infringements and not a stable article suitable for substantially non-infringing use. So here you say there are two sets of requirements to establish contributory infringement. Number 1, the components contributed to the final infringing products must be a material, very significant part of the final product. Number 2, knowledge requirements. The third party knew or should have known the components made available to the direct infringer would be adapted, would be used for making infringing products. So the component itself as a product by the third party is not infringing. What is infringing is that the factory which purchased these components and made it part of the final products. If the making of the final products may constitute direct infringements, the one who contributing the key components might also be held liable, provided that A. This is a very significant part. B. He or she knew or should have known these components would be, or this part would be adapted to infringements. Usually it will be very difficult to determine whether the third party selling components would be mentally liable or not. Because the mental elements is just difficult to be determined. Who knows whether the defendants knew or should have known the fact that the component offered by him or her would be used for infringement, would be used for the making of infringing products, right? So the two requirements must all established in order to constitute contributory infringements. In addition, there is a rule to exclude those who are selling stable articles or selling items which could be used as part of the patented invention, but the products could be used for substantially non-infringing use. If these arguments are accepted by the courts, the sellers or providers of the stable article or the article that's substantially or suitable for substantially non-infringing use would not be held liable under contributory infringements. Stable article refers to the items, the goods that's available on the open market that might be suitable for any purposes. For instance, if you were the maker or seller of mineral water, mineral water could be used for many known or unknown purposes. It could be used for drinking by mankind, being drinking by an animal. It could be used to make cakes, to make other food, right? So these kind of products, called articles, are available on the market. Anyone can buy it, and it can be used for many different purposes. So the selling of stable article would not give rise to contributory infringement liabilities. And the selling of items or any other articles that are suitable for substantially non-infringing use would also not be liable for contributory infringement liabilities. But it would be the one who providing these articles to convince the court that the items provided by him or her are suitable for substantially non-infringing use. Being suitable for substantially non-infringing use means the item, the product made or sold by me could be used to do good things or bad things. I don't know. It could be used to make legitimate products. It could also be used to make infringing products. Who knows? But anyway, it could be used for the making of non-infringing use in a substantial sense. That would be enough. So the actual provision of material parts to the making of patented invention and the knowledge requirements, there are two conditions to impose a third party the liability for contributory infringement. But please pay attention here. Even you were selling or making a stable article, the mineral water, you could also be held liable based on inducements liabilities. For example, you knew that those factories were makers of infringing patented products, and you knew that they were in short of water, which is a key raw material to make the final infringing products. You knew it, and you actively induced the operators of those factories to buy mineral water from you, to use those water for the making of the final infringing products. In this case, you could be held liable for inducement to infringements, although you were selling a stable article, mineral water. You see, but you are not held liable under contributory infringement liability. Inducements and contributory infringements in China. The two secondary liability rules developed in the US law codified into the statutes in the US have been very influential in China as well. In practice, the Supreme Court have issued many judicial interpretations concerning intellectual property protection. The inducements and contributory infringements liabilities have been adopted in those judicial interpretations. The judicial interpretations that provide for liabilities for inducements and contributory infringements in China are made under or following the basic legislations of China, for instance, the tort law of China. Article 9 of the tort law of China provides a person who abets or assists another person in committing a tort shall be held liable jointly and severally with the tortfeasor. So this is the basic law, basic civil law, which enable the judicial interpretations to clarify that the one who abets or assists means the one who induce the encourage or induce or encourage the doing of infringements. To assist the doing of infringing acts could be interpreted as contributing to the occurrence of direct infringements. Assisting the doing of torts by means of provisions of raw materials, key devices, or the venue to do the wrong things. The tort law of China provides for general principles governing the liability rules in China. In addition, Article 130 of the General Principles of Civil Law of China provides if two or more persons jointly infringe upon another person's rights and court scheme damages, they shall bear joint liability. And here, this is a provision concerning the liability for joint infringements. It's called joint tortfeasorship. Joint infringements is different from the liabilities arising from inducements and contributory infringements. Joint tortfeasorship means A and B, they are all considered as infringer. They are all directly infringed the patents. Whereas in the case of inducements and contributory infringements, Party A is a direct infringer. Party B is the one who provides A the venue, the raw material to complete the final products. you see, under the theories of inducements and contributory infringements, the direct infringer would be liable for making, selling, or importing the infringing products, whereas the third party which providing the raw materials, the venue, or other factors or materials enabling the occurrence of direct infringements would also be held liable for enabling the doing of the direct infringements. So the direct infringer and indirect infringer are held liable following two separate lines of liability rules. But under joint tortfeasorship liability rules, Party A and Party B are jointly liable for the doing of the wrong things. The theories for imposing liabilities for inducements and contributory infringements has been evolving and growing significantly in recent years. Why? Because after the rise of the internet and the growth of a global economy, in many cases, it's just unrealistic for a patent owner to sue the direct infringer because there could be lots of direct infringers. In the case of pirate movies online, there could be millions of infringers. In the case of pirating products available on eBay or other e-commerce platforms, there could be hundreds, thousands of sellers distributed all over the world. So it is just economically impossible to sue individual infringers in the digital environments in particular. So in both copyright legislations and patent legislations and any other legislation concerning the protection of civil rights in digital environments, a set of rules being developed to accommodate the challenges arising from the use of the internet and the popularity of e-commerce platforms and other online platforms for the disseminating of products, of information and materials. The rules to impose liabilities on those internet service providers focus on the so-called secondary liability rules for indirect infringements. Under Article 36 of the Tort Law of China, it is provided that an ISP service provider, an online platform operator, shall not be held liable directly for the infringing acts conducted by the user of that platform. The platform operator shall not be held liable indirectly even, provided that he or she has no idea of what's going on the platform. But the ISP, the Internet Service Provider, the online e-commerce platform providers must be careful enough to remove those infringing items upon the awareness of the facts. Basically, it means number one, the service provider, the online platform operator, shall not be held liable for direct infringements conducted by the user, the seller on the platform. Number two, unless the operators of the online platforms has knowledge of the infringements conducted by the user on the platform. Otherwise, the platform and other internet service providers shall not be held liable. But if the service providers, the online platform providers, at the first place did not know the infringing activities taking place on the platform, but later become aware of that fact, the infringing being conducted under the platform, there must be positive measures to be taken. You, as the operator of the platform, must do something to stop it, because you now already knows it. You become aware of that specific infringing item on your platform. In addition, even the service provider, the online platform operators, were not aware of the facts that infringing activities being taking place on the platform, but the patent owner sent notice to inform the platform operators that, look, be careful, and those bad guys or selling infringing products on your platform, please help us to do something. Upon the receiving of those notice, it is a legal obligation following certain rules, of course, specific procedural requirements, detailed measures. The internet service providers shall remove these infringing items. So here on the slides, a case decided by the Zhejiang High Court to clarify the extent of liabilities imposed on a service provider concerning the application of Article 36 of the Tort Law of China. If you go through the details of this court's opinion, you may have very clear understanding of the current status of rules applied in practice concerning liabilities for indirect infringements in China.